Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody, and welcome to our First Fridays for September 2025. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. Welcome to our firm's live virtual First Friday event for the month of September 2025. Our firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. Here's how First Fridays is going to work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible, and then I will answer all the questions between now and 10 a.m. Just a quick friendly reminder, due to the large volume of questions, we have over 50 questions today, this free opportunity is limited to one question per association. If you plan on submitting a question live during this session today, please include the name of your HOA or condo and your current role when you submit your question. Thank you for understanding. Okay, before we get into our First Friday questions, I just want to mention briefly that Arizona legislature closed in June, and we have 4 new bills that directly impact associations. We're going to be talking more in depth on this in our September Neighborhood Services Virtual HOA Academy, which will be the third Tuesday of September at 10 a.m. But in the meantime, I think it's 11 a.m. Sorry about that. But in the meantime, we want to just kind of give you a brief summary, just to give you a taste of what some of these laws are so that you can have them on your radar, because they all will be going into effect on Friday, September 26th. The first bill that will directly impact associations deals with homeowners associations and recording of meetings. And this applies to both planned communities and condominiums. And this bill requires that if a board records a meeting that is open to the members, so like an open board meeting, the board shall keep a copy of the recording for at least 6 months and make the unedited recording available to any member on request. So if your board is recording the meetings, you must keep a copy of that recording for 6 months of the open board meeting. And if an owner requests it, you have to give them an unedited copy of that during the time period that you have it. The next bill is Senate Bill 1378, and this bill talks about political signs and includes now in the definition of political signs, flags. So I think this is obviously a sign of the times bill. The past 2 presidential elections, there were flags that were flown for both candidates. And so now it's kind of the question mark is gone. A political flag for an election is going to be treated the same way as a political sign. And that means that you're going to have it up, a certain days. You can only put it up certain days before the election, and it has to be taken down certain days after. Okay, the next bill, the third bill that we're going to be talking about today, talks about common expense liens and foreclosure amounts. That's Senate Bill 1494. This applies only to planned communities, and it makes it a little more difficult for us to foreclose on owners. Basically, this amends Section 33-1807 of the Planned Communities Act, and for the purposes of allowing a foreclosure of an assessment lien, the minimum assessment delinquency that we need to have in order to foreclose went from being 1 year delinquent to 18 months delinquent before we can foreclose, or the dollar amount must be $10,000. It used to be $1,200. So in order to foreclose going forward, starting September 26th, the assessment will have to be past due at least 18 months, or it has to be $10,000 that's owed in unpaid assessments only. And again, this applies only to planned communities. The last bill applies only to condominiums, and this deals with commercial condominiums, so like office condominium type situations. This is House Bill 2322, and this bill addresses assessments on commercial versus residential structures in a condominium. And included in this bill are definitions of commercial structure, common expenses, and residential structures. And again, this is going to apply to commercial condominium associations. Okay, let's move forward now and talk about, and again, we're going to be discussing these bills and a couple other ones that kind of are a little bit related to HOAs and condominiums, but that don't directly impact at our September virtual HOA Academy. Okay, let's talk a little bit about our questions for this morning. As of right now, as of 9 a.m., we had 51 questions, which is amazing. Some of the questions from today's session are carried over from class number 8 of the 2025 Virtual HOA Academy. And additionally, most questions in today's session have been condensed or restated for clarity and to accommodate the large number of submissions that we have today. This is intended to ensure that questions are easily understood by all attendees. Just a friendly reminder, if you are submitting a question, please keep it short and to the point, because we won't be able to use the questions. Some people are submitting questions that are like a page long, and we don't have time to do that with the limited time we have for First Fridays. So ultimately, we'll send those question backs starting in the next month or two. We're going to start sending those questions back for clarification instead of us trying to sit through them and make them shorter and try to understand specifically what your questions are. So main point is keep the questions simple and to the point. Okay, first question. Is there a standard for an annual increase like the Consumer Price Index? So this is a good question. A lot of you are working on your budgets right now. From my perspective, you have to look at every association's documents. Tells us how we can increase the assessment rate. 99% of the documents that our firm has reviewed over many years, almost 30 years now, the documents will specifically state how to increase the assessment. And there is no standard. There's no everybody should increase it. The Consumer Price Index is dependent on what your CC&Rs say. Now, there is a state law in the Planned Communities Act that talks about if your documents are silent on increasing the assessment, or they don't tell you how to do it, or it allows the board to increase it above 20% without a vote of the membership. State law, the Planned Communities Act, would kick in for planned communities. And basically what that says is that if your documents are silent on increasing the assessment rate, or if your documents allow the board to increase it above 20% of the prior year's assessment rate, state law will kick in and they'll put a requirement that any increase over 20% would require a vote of the membership, and it would be a majority vote of the membership for it to pass. So short answer is no, there is no standard other than what is in your documents. And there's the fallback of the Planned Communities Act if your association documents don't say anything about increasing assessments or give the board authority to increase the assessment above 20%. Question number 2, any guidance or observations regarding contingency levels as a dollar amount or as a percentage of total spending? So this is a good question. This was submitted to us in our budget and finance class that for August of 2025 for our virtual neighborhood services at HOA Academy. I think I'm on my board. I've been on my board for many years now, over a decade. And I think probably a smart, and I've been the treasurer too for my association at different times. A smart way to look at the contingency is look at where you may have been over budget in the 3 years prior. And that's a good starting place to look at, okay, there's some patterns here on the contingencies. So make sure that you're setting the budget properly for each line item. And then some people say like a 10% contingency. Some people say a 20% contingency. You just really have to look at what your cash flow needs are too for your association, because if something big happens and you have no way of getting additional funds, you don't have any sort of a cushion, so to speak, you may need to have a higher contingency for your association. Okay, this question number 3. While the builder maintains control of the HOA and no owner board has been formed, is the builder required to provide financial statements and hold an annual meeting? So really good question. Best practices, of course, would be for the builder to provide financial statements to the owners if they're requested and to hold annual meetings. In our experience, that doesn't usually happen, unfortunately. What my feeling on this is, if you want the builder, when they're in control of the board, to provide you with records, the owner should be making a records request, a formal records request. And it is my opinion that the developer board is acting as a regular board and they would be subject to providing you with that information. Typically, the annual meeting doesn't happen until the transition meeting, but there is something under Arizona law that says every association has to have an annual meeting each year. So if they're not having one, you could bring that to their attention. and try to force them to comply with the law. Question number 4, our HOA has a pass-through utility assessment that recently incurred a large increase. Because of this arrangement, the individual homeowners were not notified directly of the new fee and the effective date, which has passed. Is it reasonable to request from the management company what notification of the increase did they receive and when did they receive it? I mean, of course, you can ask the management company for that verbally. I think probably the better thing to do would be make a records request for the notice that was received from the utility company, indicating there was an increase, or maybe the first bill. Ask for the bills if there wasn't a notice, and you'll be able to find your information that way. Okay, next question. Number 5, after transitioning from declarant control, should the newly elected HOA board review and evaluate the reserve study completed by the builder? So great question. We have a good cheat sheet on transition from developer to homeowner control that I would recommend that you take a look at. I guess my feeling on this is, when there's a transition from declarant control to the homeowner controlled board, you can look at the reserve study that the developer did, but from a practical standpoint, you really should look and see if that was done properly, because lots of times the developer will do it in-house or the management company will do it in-house for the developer, and the intention on it is to keep that reserve requirement low. So many times, like 90% of the times, if a professional company wasn't used to do it, like a professionally licensed and bonded reserve company, it's really not, it may not be accurate or correct. And even if a professional company did it, it may not have all the components that are needed or required for your community. So of course, take a look at it. But you also may want to get your legal counsel involved to look at it too, to make sure that, it's consistent with what the needs are for your community and that it's not intentionally lower than what it needs to be. And remember that most associations now are getting an updated reserve study somewhere between every 3 and 5 years. Okay, question number 6. There is a vacant lot between 2 homeowners. One of the homeowners has expressed interest in purchasing it. If the board were to consider selling it, we would notify both adjoining owners, obtain an appraisal to establish fair value, and inform the community at least 6 months in advance so members could discuss it with the board. Should the association move forward with selling the lot, or is it better to retain it as a common property, even though it currently requires ongoing maintenance, such as weeding and fencing repairs, and provides little benefit to the HOA? This is definitely a hot potato question for me. It's not as simple as just selling it. There's a lot of steps that would need to take place before you would ever be able to do this. First, you'd have to look in your documents to even have the authority to sell common areas. And you can imagine that those 2 adjacent owners are going to feel that's going to diminish their value of their home. And so it's technically, under your question, it's not really a vacant lot. It's actually common areas. And depending on, it sounds like you guys are a planned community. I'm not sure that you even have the legal authority to do that. And you would possibly have to do an amendment to the CC&Rs, an amendment to the plat, get a vote of the membership. And you'd have to look at the change of use provisions under your documents. And also, I believe that it might require unanimous approval from those 2 owners in order to do that. But I'd have to look at the issue a little bit more carefully. So this is something you definitely need advice from your legal counsel on before you would think about doing. And it will be difficult to do if you are able to do it. Okay, next question, number 7. What are the guidelines or law around a board member also being paid as a bookkeeper for a small self-managed community? Well, what I would suggest you do is look at your association's documents and see if board members are allowed to receive compensation. That would be the first thing that I would look at. I think it's in the Nonprofit Corporation Act. It says that in order for a nonprofit board member to receive compensation, it has to be in the bylaws. It's very unusual to have this situation where a current board member is also getting paid to be the bookkeeper. And does this person have enough expertise to be doing that? We also see this oftentimes too, like, we won't make them pay their assessment if they act as the president or the treasurer of the association. It's generally just not a good idea to do this. You should have somebody who is not on the board serving in this role for your community, and they do need to have experience and expertise. Let's see. So guideline would be it's best practices not to do that. Question number 8, Arizona law requires an annual audit, compilation, or review. If the bylaws don't require it be done by a CPA, who can do this for the association? Really anybody. Sad to say that the law isn't written very well in Arizona on this particular financial controls of having an audit review or compilation done. So if your bylaws don't require it to be done by a CPA, you could have the management company do it, the treasurer, you could bring in an outside bookkeeper, you could have a committee that's formed by the association to do this. Really, any of those people check the box to have it comply with Arizona law. We do suggest that every year that you fill out a form indicating what the audit review or compilation was for the prior year by June 30th after the fiscal year ends. Okay, question number 9. Can an HOA with taxable interest in the reserve fund reimburse their operating fund, which paid the taxes? Okay, this is kind of a hot topic right now because what we're finding is that because of the high interest rates, a lot of associations who have had CDs over the past 2 years have been making money on the CDs. And so a question that comes up with is our interest on our CDs maybe created $20,000 or $30,000 in income for our association. And now when we're filing our taxes every year in March, we're having real money on that taxable interest that was earned. And so the question is, can an HOA that's in this situation reimburse their operating fund, which paid the taxes? That's really a question for your CPA, for your association. I'm not a CPA. I do know that there are, and basically what they're trying to do is say, hey, we shouldn't have to use our operating funds money to pay for something that was caused by the interest in the reserve account. I don't know the answer on this. I think associations have handled it both ways, but I would ask a CPA for formal clarification on that. Okay, next question, number 10. Knowing that Arizona statutes trump the CC&Rs, what are the state requirements for removing a board member for missing meetings, as our CC&Rs are rather restrictive? Also, do workshops count as an official meeting of the board? So the first question is on removal of directors from office. What are the state requirements? It's kind of extensive for me to answer here in this question. But what I would do is point you to our cheat sheet, our top 10 cheat sheet, top 10 things you need to know about Arizona law. Number 6 on that gives you the procedure for removing a director from office. There's a whole process. You have to submit a petition based upon the number of lots or units in your association. You have to have a requisite percentage of owners signing the petition. And then if they have the requisite percentage, then we have to have a meeting of the membership to vote to remove the directors. And there's a special quorum for it. So state law is very specific about how to remove a director from office, and check out our cheat sheet on that particular topic on the top 10 things. We may even have a new cheat sheet too, I think, on removal of directors. That might be helpful for you. I know it's either in final form or it's close to final form. So what about a board member missing meetings? I think what's happening in your association is your bylaws likely say that if you miss 3 meetings in a row, a director can be removed. We really have to look carefully at the language in your bylaws on that, because sometimes it says that they automatically resign. And if that's the case, it's probably okay. They probably automatically resigned. That's what your documents say. But if it says that the board can remove them for missing 3 meetings, then state law would kick in and you wouldn't be able to remove them unless you followed what state law says. Do workshops count as an official meeting of the board? Yes, they do. If you have a quorum of the board there and you're discussing association business, even if you're not voting on something. Okay, next question, number 11. The management company claims emails from other board members are not part of the corporate records. Is this true? No, that is not true. If there's email communication going on between directors, this is most definitely something that could be discoverable. And if an owner requests it, it is a record of the association. I'm assuming that they're discussing official business. Lots of times directors are emailing about association business. If they're emailing about personal matters, it would not be discoverable and it would not be able to be requested. But if it's regarding association business, yes, definitely. This is a book and record of the association. Question number 12. If the co-owner submits a work order regarding a hazardous tree in the common areas, describing it as potentially life-threatening to their family, and the board of directors takes no action for 3 months despite repeated requests, what legal liability could the board and the association face if the tree falls and causes a fatality? Well, I think anytime a board receives a request like this from the owner, they do have a duty to investigate it in a reasonable time period. And I don't know what the board may or may not have done here. Sometimes we get requests like this and we send the landscaper out to look at it right away and they say, hey, this really isn't a hazard and we're not going to do anything about it. It may take a little bit of time in the chain of command to talk about it at a board meeting and then respond to the owner. But if it truly is like about to fall over and it could harm somebody, the board should be taking action in an efficient and speedy manner. And is there liability? Possibly if the tree falls and causes a fatality, if the board is found to not have acted in a prudent manner after becoming aware of the issue. Now, let's just say that the tree falls and we had no notice. I mean, there still may be liability, but that's why we have insurance. Okay, question number 13. We are unhappy with our management company and our manager. Can our board meet to discuss our concerns prior to addressing our manager, or is that a violation of the open meeting law? Most definitely, your board can meet to discuss this. This is job performance of one of your contractors, so you can have a special executive session to talk about this. I think it's best to just be honest with the management company and say, hey, we're going to be doing a review of the manager and the management company, and we're going to be having a executive session, and we don't want you to be there because we want to be able to talk in confidence. And just ask them to notice it. I wouldn't sneak around and do it behind their back because they're going to find out about it, and that's not going to be a good situation. And, during that meeting, you can talk about the performance. And obviously, after you come up with your plan of how you're going to handle it, you may want to talk with the management company about it. Talk with the manager, talk with the management company's head of managers regarding your concerns and come up with an action plan for them to improve. Whatever you do, don't fire them in the executive session. That needs to be done in the open session if that's the direction you're going. Okay, next question. Number 14. What is the best practice for budgeting recurring maintenance expenses? Should they be listed as a regular line item instead of contingencies? Also, the CC&Rs do not cap annual fee increases. Does Arizona law impose any limit? Okay, best practices for budgeting maintenance expenses that are reoccurring. I'm not quite sure how you can anticipate maintenance expense. You can put it as a line item. That would be what I would suggest, because especially if you look at your reserve study and you can see, okay, this is probably going to be something that needs to be handled in 2000 when you're doing your budget. But I think you can really do it both ways. I'd probably have a contingency no matter what, and then have a line item for if it's in your reserve study that, hey, the pool pump's going to be needing to be replaced. You could put that in your budget for 2026, et cetera. But it's hard to anticipate. So, I think it's kind of a hybrid there would be the way to go. I already talked about the second half of the question about CC&Rs not capping an annual fee increase. If you are a planned community, I don't know if you are one or not. I think you are based upon your name that was submitted. Then you need to look to state law, and state law says anything over 20% would require 51 vote of the membership in order to increase above 20%. Anything under 20%, if there is nothing in your CC&Rs on how to do a fee increase, then the board could raise it up to 20%. Next question, number 15. If our articles require the board to audit financials and provide a yearly report, but our elected board has not done so and left it entirely to the management company and accountant, are they failing to fulfill their obligation? Well, it depends on the specific language of your documents regarding the audit. Does it say that the audit has to be done by a CPA? I don't have your documents, so I don't know. I think I would need to see your bylaws or your articles before I can comment on that, the specific language. If it says it has to be done by a CPA, then it has to be done by a CPA. If it doesn't say it has to be done by a CPA, the audit, then really the management company or a bookkeeper or the accountant, any of them, they would still be in compliance with Arizona law if they had them doing that. Now, again, mind you, you don't want the fox guarding the hen house. You really should be having an independent person looking at the year-end financials and to do a review or a compilation. Independent person would be the best for the association. Okay, next question, 16. If we have a lawyer that represents the association, does that include the board regarding working on behalf of the association? I'm trying to understand for me personally and for the board Do we need personal lawyers to represent each of us in our capacity as board members? So really good question. So short answer on that would be no. The association hires an attorney to represent the corporate entity, the association, and you don't really need personal lawyers as directors. You're just serving as a director of the association, and the association hires a legal counsel. Now, if for some reason you're sued, you're named in a lawsuit, the association should tender that to the association's insurance carrier, and the insurance carrier will hire an attorney at the expense of the insurance company to tender a defense on your behalf. If you are personally named in a lawsuit, that's the pivot, that it's tendered to the insurance company. They assign somebody to defend you in the matter. So you wouldn't need a personal lawyer. That would automatically be assigned by the insurance company. And just in your day-to-day affairs, acting as a board member, you do not need a personal lawyer to represent you. The corporation or the attorney for the association is going to be advising the association on how to best handle things. Okay, next question, number 17. Can an HOA require residents to register their dogs and pay a $20 fee if the governing documents do not address this requirement? Probably not. They probably can't require this. I mean, I'd have to see how broad your rulemaking authority is. But also from a practical standpoint, what happens is like the people that, I'm guessing you're doing this because there's problems with the dogs, maybe people aren't picking up after them, or maybe there's unleashed dogs, or maybe there's concern about dangerous breeds or something. Or maybe they think that the pound limitation that you may have in your documents isn't being complied with. The reality is the people that are violating whatever rules you're trying to enforce, they're not going to register their dogs anyways. It's going to be all the people that follow the rules. So I think it kind of backfires even if you would be able to do it. And you probably would require an amendment to the CC&Rs, especially if you were going to charging a fee. Okay, question number 18. How does declarant control apply to subdivisions subject to restrictive covenants, but without an HOA, given that Arizona law uses this term only for planned communities with HOAs? So there are a lot of associations, mainly in northern Arizona, where they may not be considered planned communities as defined under the Planned Communities Act, but they still have restrictive covenants that govern their land. And so, for example, maybe you buy a home in an area and there are recorded restrictions on the property that govern, like, you can do this, you can't do this type of things. Like you can only have 2-story houses, or there has to be a minimum square footage of the homes in the neighborhood. But there's no board that's running things. And maybe there's no common areas. And maybe there's no streets that are being maintained by the association. So it's possible that you're not formally a planned community. So how does declarant control apply to these subdivisions? I mean, it really depends on what those restrictive covenants say about the developer, the person who's selling the land. Usually, in my experience, there isn't typically like a declarant control period in those type of associations. Usually the developer is just selling. They have a big parcel of land. They subdivide it and they put CC&Rs on all of the land, and there's no fees that are collected. There's no association that's enforcing the documents, and it's just the restrictive covenants are on the property. And if you have a disagreement with a neighbor, the right to sue is between the two neighbors. There's no entity, there's no association overseeing things. So typically we see with those associations that just have covenants, but no board or no formal association, no assessments being collected, this declarant control thing really doesn't apply. Okay, question number 19. Should architectural change requests be discussed in executive session as personal matters, or is it proper to handle them in an open board meeting? So architectural change requests, if the board is reviewing them, should be done in an open board meeting. If you have a separate architectural control committee and they regularly meet, like the first Friday of every month, that should be done as an open meeting for the architectural committee too. This should not be ever done in an executive session unless there's some sort of like an appeal or something, like on a denial and the board's hearing it. Then the board can put it in an executive session unless the owner wants it placed in the open session. If that happens under Arizona law, we have to move it back to the open session. Okay, question number 20. What options does an HOA have when a vacant townhouse owner is paying property taxes, but not association dues, and the home's condition may affect neighboring units. Okay, a couple things. So if you have an owner that's not living there, it's vacant, right? They're paying their taxes probably because the mortgage company is probably paying it for them, if I had to guess, it's part of the mortgage, but they're not paying their dues, and now the home's condition is getting really bad. Definitely turn it over to our firm. We can help you with that. My best advice is have us do a credit review of the owner, and we can look at, is the property underwater? Is there equity in the property? Does this owner have judgments against them? Does this owner, they have high credit card debt? What is this person's financial condition? And then we can give you advice on what's the best way to collect the money. I would put a lien on the property, and I would definitely have the attorney send a letter regarding the delinquency and the condition of the property. You also can fine the owner or the condition of the property. You may have self-help where you can go in and clean up the property. So definitely reach out to our firm. We'd be happy to help you with that. Okay, question number 21. Can a non-owner in escrow submit an architectural change request? And should an HOA provide an appeal process for committee denials if the CC&Rs are silent on appeals? So this is a really good question. So sometimes you'll have a buyer who wants to know in advance if they can make some sort of a change to the property. And the buyer tries to submit an application to the Architectural Control Committee or to the board. It doesn't happen that often, but I have seen it happen. So not proper. The association should not entertain applications from non-owners. The way to handle it is to have the owner submit it and have the owner ask for permission with it with detailed plans. And then the board can review it. And the owner may say, if I sell my property, the buyer of my home may want to do this. We're just making you aware of that. But that is how I would handle it. I would not have a non-owner be submitting requests. It has to be done by the owner. Next question on the same line is, should the HOA provide an appeals process for committee denials if the CC&Rs are silent on appeals? You certainly can. Like if a homeowner is aggrieved by a decision by the Architectural Control Committee, the board certainly can hear it, even if there's nothing in your documents, but you're not required to if it's not in your documents. Okay, next question. We have an elderly owner with a son or an heir who has a history of violence and drug abuse. Can an HOA amend its CC&Rs to require board approval? Let's see. Can the CC&Rs require board approval of new homeowners? And would such a rule apply to relatives inheriting units? So short answer on this is no. I think that potentially would be a fair housing violation because we really don't have any grounds to refuse to have an owner purchase property in our neighborhood or in the association. Probably the best way to deal with a resident that has a history of violating the law or maybe not abiding by our association's documents is to go through the legal process of having the association's attorney send a demand letter to the owner, whoever the owner is at that time, potentially filing a lawsuit, contacting the police to make police reports regarding any behavior by the resident. But we can't prohibit that particular person from inheriting the property, or we can't prohibit future owners from buying in, because I think it would be a fair housing violation. Okay, next question. Question number 23. Can an HOA take action or inspect a unit that has been abandoned for 20 years but is still paying dues if it poses a health risk such as a rat infestation? So I'd really need to look at your CC&Rs. Like, do your CC&Rs say anything about this, such as, do you have a right to enter a property if you are concerned about a condition in the property? I see that you are a condominium, so I'm guessing you probably do have that provision. I think you'd have to have reasonable cause to do that. And then you would have to give the notice provisions, whatever the notice requirements are in your documents before you can do that. Okay, next question, 24. What steps can a board take to prevent social media pages from becoming sources of conflict and to minimize legal risks when launching or moderating a community Facebook group given past issues? Whoa, this is a hot topic. I have a number of issues like this in my office right now. I think the biggest thing that I would recommend is that the board should not be commenting ever on social media pages about anything. The only thing that I would be okay with is if somebody's saying something on social media and the board feels that they need to respond, you could respond, please come to our board meeting to ask this question, and we'd be happy to talk with you. If a board has a social media page, I would recommend that you turn off the comments and you just put like very neutral information on there, like when the board meetings are, or if there's going to be repaving of the parking lots, how the repaving is going to be handled. I don't think it's a good idea to have social media as a bridger of disputes, having both sides fighting on it. So it can be a good thing because it helps us get the word out, but it can be a bad thing if people are just fighting and engaging in unprofessional behavior. Okay, so let's see. So what steps can you do? The board shouldn't be commenting on social media. And if social media is becoming something that's not helpful for your association, just get rid of your social media accounts for your association. Okay, question number 25. Should the full board meeting packet, including agenda, minutes, financials, and supplemental materials, be retained as part of the official records? Or is it sufficient to keep only select documents like the agenda, minutes, and financial reports? Since everything is digitalized basically now, I would just keep the whole packet. I think that would be best practices. Question number 26. Is it common practice for HOAs to include in their bylaws a dollar limit the HOA board must get homeowner approval to spend out of reserves? If so, do you think that $5,000 is too high? So no, it is not common practice to have a dollar limit in terms of how much the board can spend out of the reserves. That is not something that's normal. And in fact, when I see that provision in documents, I always take it out when we're doing an amendment. Do I think 5,000 is too high? No, absolutely the opposite. I think 5,000 is too low. And I think that this is not a good provision to have in your documents because it severely limits the board to handle emergencies that may occur on their common areas. Okay, question number 27. For our association's annual meeting agenda, can board members add to agenda items ahead of any time, any restrictions? And do all board members need to agree on the agenda item to be added? This, of course, is in advance of sending the agenda out to all homeowners for the meeting. So I get this question a lot when there's a lot of contention and fighting on a board. And in a perfect world, if you have a management company, the board president and the manager work together to create an agenda. And maybe the agenda is routed to the other board members in advance. Maybe it's not for input. And there's no fighting on it because pretty much there's lots of opportunities for board members and homeowners to be able to make a comment at a board meeting. So when I see something like this, I kind of feel like, oh, there's a lot of contention already in this association. So what I would recommend if we have an association that's fighting about the annual meeting agenda or a board meeting agenda, I would set up a protocol for the board, and it likely would be that the manager creates the agenda with the president, and then maybe they route the agenda around to the rest of the board. And if anybody wants to add anything, it needs a majority of the board to add anything to the agenda type of thing. But really the annual meeting agenda it's always the same. Like I've been to thousands of annual meetings over the past 29 years. And I mean, there really shouldn't be anything unusual on this because it could fall, usually you approve last year's meeting minutes. You have a president's report, a treasurer's report, a manager's report. You talk about old business, new business. You have a homeowner forum. You vote on the election of directors and you announce the election of directors. Maybe there's a special issue like a CC&R amendment or a special assessment or an increase in assessments that requires a vote of the membership. And then everybody moves on. You should be able to have something fall under one of those categories without having to fight about the agenda. Okay, question number 28. Do you endorse the use of the Arizona crime-free addendum between landlords and tenants in a condo complex? The Arizona crime-free addendum is a lease addendum, sometimes found in Arizona rental agreements, that allows landlords to evict tenants based on vague accusations of criminal activity without requiring a criminal conviction. It also can say something like if you're convicted of a crime or there's criminal activity that you've been convicted of on the property that we can evict you. I mean, I'm kind of neutral on this provision. You're going to have to amend your documents to include this. So this is something that you can't just require without having it being in your association's documents. And I would say this is kind of rare to see this in the documents. Okay, next question, number 29. If a board member makes a motion but the president paraphrases it differently during the meeting, which version, the original motion or the president's restated motion, should be recorded in the minutes? Whatever the languages that the owners voted on that whatever language that the board members voted on is going to be the language that is in the minutes. So if a board member made a motion and then somebody asked somebody to rephrase it and the president rephrases it just a little bit differently, and then there's a second to the rephrased, then that's what should be recorded in the minutes. If there's a correction that needs to be made, you can do it at the next meeting. You can vote to undo the prior vote and make a new motion with whatever language you think should be the right language, and then have a vote to approve whatever you think is the right language after a second. Okay, question number 30. If 3 of 5 board members resign and only 2 remain, do the 2 board members constitute a quorum under the CC&Rs? And how should the board proceed with filling vacancies and holding future meetings? Really, the answer to all of this is going to be in your documents. I'm guessing that 2 out of 5 is not a quorum, but the 2 are going to have some special powers because they're the only ones in control of the board at that point. So they should be able to look at the documents, have your attorney help you by looking at the documents to determine, can you appoint somebody to fill the vacancies? That's typically what we see, or do you have to have a special election, which is kind of more rare. Okay, next question, number 31. If a candidate for a board election receives enough votes but is delinquent on dues, can they be disqualified from serving? And what is the appropriate process for notifying them to avoid embarrassment? The only way that you could disqualify a candidate from serving for not paying their dues is if that is specific requirement in your document saying that you can't be delinquent. And that if that occurs, if it is in your documents, which is very rare, you should be talking about this with the candidate before the election, and they should be getting themselves current before they're elected, because if they aren't current when they're elected, they're not elected if that's what your bylaws say. Question number 32. How do other communities handle requests to use artificial plants or planters to meet shrub and landscaping requirements, especially when the CC&Rs do not specify live or in-ground plants? That's a good question. I have not had that question before. We've talked about artificial turf, and of course, Arizona law is you should be allowed to have artificial turf under certain restrictions under Arizona law if you want it on property that you own on your lot. But I really haven't had an issue with artificial plants or planters. I think, in my opinion, I probably would have to look at what they're proposing to do. And the Architectural Control Committee or the board would have to look at it and see if it's something that they're agreeable with or not. So I'd have to know more about what you're planning to do and how realistic they look, et cetera. And you have to factor in if there's sun damage to it, they have to replace it, et cetera. Okay, next question, number 33. At an in-person annual membership meeting, can members make and vote on motions, or is it discussion limited only to board member announcements, committee reports, and the yearly summary? It's a really good question. So at an annual meeting, can members make a motion, and then can the entire whoever's at the annual meeting vote on it? Yes, but there's a problem to this. It is the membership meeting. Annual meeting is the meeting of the membership, but you're not going to have, very likely, you're never going to have a quorum actually there live in person, especially because absentee ballots are used now very frequently, and we typically have a handful of people actually come to the annual meeting. So you can make a motion, of course, but you're not going to have likely a quorum. And so you're not going to have enough votes to have anything like that pass. But what I would say is, instead of making a motion, why don't you just bring the idea to the board during the homeowner forum as to whatever you want, and then the board can consider whether to discuss it at a future board meeting or a future meeting of membership. Okay, next question, number 34. If a tree located in a common area falls and damages a resident's wall during a storm, is the resident responsible for part of the repair cost, and does the act of God clause apply? So this is kind of an unusual situation. I have seen this happen before, and we've had a lot of storms in Arizona in July where there was significant property damage. What the best way to handle this, in my opinion, is if a common area tree falls and damages an owner's property or a vehicle or a garage or whatever, typically we contact both insurance companies and let the insurance companies figure out who's going to pay it. Okay, next question. Number 35, what happens if an association's audit, review, or compilation is not completed by the statutory deadline and the governing documents do not address late completion? Unfortunately, this happens pretty frequently. So here's how the audit, review, or compilation deadline works. So let's say our fiscal year for 2024, it ended December 31st. By June 30th, you should have the audit, review, or compilation done. And either you have a CPA do it and they actually give us an audit packet with their findings on it, or you have a third party or the management company or the treasurer signs a piece of paper. What I found is quite often the CPA is behind on getting it done. And maybe the association doesn't even fill out a paper on it. And so there's no paper trail on this by June 30th. You should make your very best efforts to have that audit done. And the best way to do that is to give it paperwork to the CPA early in January and tell them we need this done by June 30th. If you give it to them like in May, it may not be possible for them to get the audit done by June 30th. So act early, give them a deadline, follow up with them. If it's an internal thing, it's typically they're just signing a piece of paper after they review it, and just be aware of the deadline and make sure that they're complying with it. I haven't seen any association be sued for this. So, what happens? Usually you get a reminder and you get it done. I haven't seen any lawsuits on this. Okay, next question, number 36. Can the board of an HOA that is both a 501c4 nonprofit and a planned community under Arizona law take unanimous action by email, or does this violate Arizona open meeting laws? It's my opinion that the Arizona open meeting laws trump the Nonprofit Corporation Act's provision that talks about action by unanimous written consent. And so any decision by a quorum of the board should be done during an open board meeting. There are 2 administrative law judge cases in Arizona that have agreed with my interpretation on this as well. Okay, question number 37. We are self-managed HOA who will be interviewing for a new manager. Before offering the position to a candidate, is it necessary to conduct a background check? Who does this? What is the cost? So I think it's a good idea. Obviously, you're going to want to notify them and get consent. Before you do this, I would recommend that you do that to notify them that this is part of the compensation package and that we're going to be, doing this as background information. Who does this? You can either go to a private investigator or have your attorney help you with this. And the cost, it really depends. It could be anywhere from like $500 to $1,000. Okay, next question, number 38. Our property manager is performing poorly and some board members want to replace the management company. Does this decision require a full community vote, or can the board decide on its own during an open session after executive discussion? My opinion on this is that, assuming that your bylaws don't conflict with this, which I'm pretty confident they won't, really, this is a board decision and it should be done in an open board meeting. Okay, question number 39. Can a committee chair decline to notify or prohibit interested owners from attending committee meetings, which meet as needed via Zoom or in person? If not, what resources are available to the owners who wish to attend? So it depends, a couple things. So if the committee meets regularly, it needs to be an open meeting. And if you're having it by Zoom, you should be noticing the homeowners 48 hours in advance of the meeting and giving them an opportunity to join on the Zoom link. If it's not a regularly scheduled meeting, you're not required to do that. But why wouldn't you? I think we want to have good communication with our owners. And so I think committee chairs should not be declining if owners want to attend a committee meeting, but they are not legally obligated to do that if it's not a regularly scheduled committee meeting. Okay, question number 40. I'm just going to do a quick check to see how many questions we have here. Total, we're up to 53. Okay, so number 40. Is the board required to present itemized bills to association members on a request for repairs done in the community? You're not required to, but if an owner makes a records request to see that, you do have to comply with that records request if you have the documentation on the repair bills. Next question, number 41. A unit owner in our high rise is severe hoarder, filling the condos wall to ceiling, but keeping it contained inside, so nothing spilling into the common areas. A neighbor saw the inside and raised fire safety concerns. Our CCNRs only say owners must keep units safe, sound, and sanitary. What authority does the HOA have to investigate or require her to address the issue if she refuses access? Well, a couple things. You may want to just send a letter to the owner indicating that there's concern about this. It'll have to be carefully worded. You may want to involve the city. Many of the code enforcement departments might go out and investigate this. But realistically, if it's being contained inside and it's not like a fire hazard or safety concern, there's probably not much you can do. Okay, question 42. Was it appropriate for me as a board member to research and share findings about a charitable organization's clubhouse rental and suggest a fee waiver? The president responded to the entire board saying, "That's nice. I said I would inquire and I will. Stay in your lane unless I ask for your assistance." He went on to email the entire board again. "If there's any question as to the organization structure of the board, feel free to contact me and I will explain it with small words and I will talk real slow." Who was out of line, me or the president? Did the president overstep with harsh emails and exclusive claims to board authority? So if you're both board members, I do think that probably unprofessional behavior on the part of the president. You certainly are within your rights as a homeowner or a board member to ask the board if a nonprofit is asking to use the clubhouse, can we waive the fee? They don't have to waive the fee. But I think just kind of goes back to this is a business. And petty disagreements between board members, that we really need to put those aside. And the board president's the leader of the team, and they need to be acting professionally. Okay, next question, number 43. After her appointment expired, the board president refused to vacate her seat or hold a required election, continuing to act as the president. Since then, she has made decisions and signed a vendor contract without board approval, creating a costly contractor dispute and potential lawsuit for the association. Given that she was not a legitimate board member at the time, does the contract bind the association? And could she be personally excluded from D&O coverage if we are sued? A couple of questions on this. So I don't really know, because you're kind of contradicting yourself in this question. So this board member was appointed to the board and there was no election for that seat. So typically a board member remains in their seat until there is an election and their successor is elected. Maybe they're reelected or a successor takes their place. So, I don't know the specific facts here, but it's kind of contradictory because just because her appointment expired, you still need to have an election to elect the person to be, the new board member. I recognize that you think that probably she's refusing to have an election, but she's probably still the president and still a board member. And should this person be making decisions on behalf of the board without their authority, without their approval, without their knowledge? No. But she appears to have authority, the contractor, and I don't think that the contract can be withdrawn. I don't think it can be voided. This is a sticky situation, so you definitely want to get your legal counsel involved. Will she be covered under the insurance? Likely she will, because it sounds like she's still a board member. Okay, number 44. Several residents receive violation notices for parking commercial vehicles, yet our CC&Rs only prohibit vehicles exceeding 3/4 ton or certain types like trailers and boats. Is there an Arizona statutory definition of commercial vehicle? And do mid-sized pickups with small business decals qualify under state law or our HOA's restrictions? So there is an Arizona law which defines commercial vehicles. It can be found at ARS 28-5201 and 28-601. It's really hard for me to comment on this because I haven't seen your CC&Rs. Typically, your CC&Rs are going to define what can be parked in your neighborhood and how it can be parked. And we have to comply with that. If it doesn't give us a definition of a commercial vehicle, I probably would say that if somebody has a business decal on it, it could be considered a commercial vehicle. But I'd have to look at the totality of the circumstances, including what did the CC&R say, what does state law say, and actually look at the vehicle and the decal on the vehicle. Okay, next question, number 45. If we signed a code of conduct as a board, what are the potential legal consequences if a board member knowingly or negligently chooses to violate it? It's potentially a code of conduct is to encourage good behavior by the board members. If somebody violates it, it should be brought up in an executive session, likely with your attorney present. It's possible it could be grounds for a recall petition, or it could be grounds for request for that person to resign from the board. It really depends on how the code of conduct is written. And usually the person that's violating the code of conduct, they're not going to quit and they're going to continue to violate it, in my experience. And that may be where you want to get the attorney involved and have the attorney write them a letter about them breaching their fiduciary duties to the corporation. Okay, question number 46. This is our first year using online ballots. Since our meeting location has limited internet, we plan to close online voting before the meeting, then add any paper ballots submitted at the meeting to the online results. Election Buddy notes that no votes can be added once online voting closes. Can we still combine the paper ballots with the online results after the online voting period ends? So short answer on that is yes. We are required under Arizona law to accept in-person ballots at a meeting of the membership. So that is the way to do it. You just add the numbers together. It's no big deal. Okay, question number 47. Can we remove random lock boxes attached to the railings in the common areas? Our rules prohibit owners from placing personal property in common areas. This is not for units listed for sale. These are expected. So I'm guessing like these are like lockbox. I'm not really sure. Maybe it would be for like their tenants or something, or a short-term rental or something. I think I would talk about it with the owner before I would start removing them, because you might want to explain that we don't allow this, although if you're allowing it for the units listed for sale and kind of wondering why this is such a big deal, and it may not be a violation. I think I would just talk about it with the owners. And frankly, I don't know how big these are, but it doesn't seem to me like it's that big of a deal. Okay, next question. Let's see. Number 48. If CC&Rs do not cap regular or special assessments and authorize them to protect property values and maintain common areas, does Arizona law limit the board's ability to raise regular assessments or levy special assessments for non-capital maintenance? Or are these increases allowed if approved by a member majority or delegated to the board? So your CC&Rs have no cap. I don't know if you're a planned community or a condominium. So if our CC&Rs don't cap any assessments, regular or special, and it requires the board to take action to maintain our common areas, does the board's ability to raise assessments, do we have any limits on it? So we've talked about this twice now already today. It depends. Are you a condo or are you a planned community? If you're a condo, there really aren't any restrictions other than what's in your CC&Rs. If you're a planned community and your documents are silent about these increases, I have to look at the documents, but you want to fall back on that. Anything over 20% would require a vote of the membership. If it doesn't mention a special assessment, you may not be able to do a special assessment if you're a condo or your planned community. So you really need to get legal advice from your legal counsel before you take any action on that, because those are the type of things associations definitely get sued for. With Santan Valley Incorporating, next question, 49. With Santan Valley Incorporating, will going from unincorporated county to town affect what limits my most local municipality can place on the HOA? Does town law supersede county law? That's a really good question. I'm not quite sure how that is going to affect you. So I guess Santan Valley is becoming a municipality. And so it's just going to be like any other municipality. So it can't be. So the association's documents can be more restrictive than whatever Santan Valley's potential codes may say. And of course, any members would have to be in full compliance with any Santan Valley ordinances or restrictions. But the association can also be more restrictive if they choose to be in CC&Rs. Next question, number 50. Can board members approve revised sets of bylaws? My knowledge was that they needed homeowner approval to pass any change of both the CC&Rs and the bylaws. That really depends on what the bylaws say. Do the bylaws require a vote of the membership, or do the bylaws allow the board to change them without a vote of the membership? So look at what the amendment language says in the bylaws to make a determination on that. If the board has the right to amend the bylaws, they should do it at an open board meeting, and they should give 48 hours notice, and the meeting agenda should list what the changes to the bylaws, what's going to be voted on. Okay, question number 51. Our HOA board called an emergency open meeting to approve gym equipment after being notified of an 8.5 tariff surcharge and possible inventory issues if we didn't act within a few days, which saved us about $4,000 or $5,000. At the meeting, 2 board members and the spouse of one declared it illegal due to notice requirements and said the purpose didn't qualify as an emergency. Was it proper to call this as an emergency meeting? So I would say yes. I think that's fine. You significant savings, but you should take minutes of the emergency meeting and then, at the next meeting, read those minutes into the record. You may even want to reaffirm the vote at the next regular board meeting. Okay, we're down to our last 4 questions. Do architectural committee approvals and denials need to be voted on by the board? Not necessarily. I mean, it depends on how your architectural committee is set up in your community. Is the architectural committee a separate entity that has the authority to approve or disapprove applications? If so, then really the approvals and the denials do not need to be voted on by the board. Maybe there's a right to appeal to the board. In some cases, your board acts as the architectural committee. So I really have to see what your documents state. Okay, next question, 53. Can an architectural or landscaping committee make RFC decisions with board approval on behalf of the board if allowed by the governing documents? I'm not really sure what RFC stands for. I'm guessing maybe like architectural. It's hard for me to answer that question because I don't know what RFC is. So maybe write back. You can email me directly and I can answer that. Question number 54. The Arizona Open Meeting Law, I thought, did not include HOAs whose meetings are covered under the Planned Communities Act. Not sure that's a question. So let's see. What are you trying to get at here? I'm not sure what the question is on that. So I can just let you know that planned communities and condos are subject to the open meeting law. And we have a cheat sheet on the open meeting law, which you're welcome to take a look at it. You can find it on our website at mulcahylawfirm.com. Question number 55, which is our last question for today. Sounds as if the treasurer can do our audit. Is that true? If not, how do we find someone to do the audit? So we had a lot of questions on the audit review or compilation today. Probably a good time for us to write a newsletter article on this. So basically, check your bylaws. Do the bylaws require you to have an audit done by a CPA? If yes, you must hire a CPA to do it every year or amend your documents to take that permission out. If your documents don't, really anyone can do the audit, review, or compilation. It could be the treasurer, the management company, a third party. If you need names of a company, that bookkeeping company that might be able to help you, you're welcome to reach out to our firm, and I'm happy to provide that to you. Okay, so that's it for today. We got through a lot of questions in 1 hour and 9 minutes. Today, we had over 90 people at our peak that were listening in, so that's a great turnout. I just want to let you know that our firm has 2 more classes this month that we want to make you aware of. We have 1 in-person class in Scottsdale, and then we also have a virtual class coming up here soon. So class number 9 is our 2000 virtual HOA condominium and HOA academy class. That's going to be online on Zoom, and that's going to be on Tuesday, September 16th from 11 a.m. till 12 p.m. And that's going to be on Zoom and Facebook Live. You can find out more information on that on our website, mulcahylawfirm.com. We're also going to be talking about the 2000 legislative update in that class, insurance challenges, and community safety. Then we're going to be teaching 1 in-person class in Scottsdale at the Scottsdale Neighborhood College on Thursday, September 18th from 1 o'clock to 3 o'clock p.m. at the Mustang Library in Scottsdale. And you can find more information on that on our website. We're going to be talking in that class about working with your community manager and management companies. We're going to be talking about hiring them, firing them, how do we handle problems. And we're also going to be discussing the 2025 legislative update in that class. And don't forget that our next live virtual First Friday event will be taking place on Friday, October 3rd, 2025. Thank you again for being here today. Have a great month of September, and we hope to see you soon at one of our upcoming classes. Take care. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.